SJC-11538, Elaine Holmes v. Kenneth Holmes.
Can you get Jay?
Can we start the clock? Oops. Thank you. Good morning, counsel.
Mr. Chief Justice, Justices, may it please the Court, I'm Sandy Derlin, Schmidt and Federico in Boston. I represent the appellant, Kenneth Holmes. I would briefly like to echo the sentiments expressed earlier today by the counsel in the other family law matter, and hope to get some clarification from this Court on behalf of my client on when the durational limits as expressed in the new Alimony Reform Act begin, or put another way, how you would calculate those durational limits. In the trial judge's decision, I think a plain reading suggests that she calculated the duration from the date of the judgment of divorce in the context of the length of the marriage, as that's defined in the statute. And I think in the context of this appeal, that was an abuse of discretion. It results in a decision whereby my client will pay alimony according to a duration which is roughly equivalent to 100% of the length of his marriage, when the statute, based on the length of the marriage, as defined in the Reform Act, calls for no greater than 80%.
What if the temporary payment were $20? I mean, $100 for whatever reason. I mean, it was a tiny amount of money. And the alimony award was exponentially greater. Anyway, just different, quite a bit more. Is it fair to count that in there?
Well, I think in that context, Justice Botsford, the statute actually allows for deviation. 53E, Section 53E, indicates that when calculating an initial order or a modification, deviation can be made provided findings are made.
But this is going to the duration, right?
Right,
Isn't that
so I think so if the trial judge felt that $20 was too small an amount in relation to the final order, and in this case it was $360 or $370 on the temporary basis and jumped up to about $700. I think the trial judge at that time could say, in light of intervening circumstances, in light of the fact that it was an artificially depressed or whatever the basis was, the judge at that time could choose to deviate under 53E. But the duration itself indicates that alimony is paid under a court order. It doesn't say, it's not limited to a judgment. It's not.
Mr. Derlin, it does speak about order and judgment somewhat inconsistently throughout the new statute, and there is a separate statute under Section 17.
17, yes.
That speaks to temporary alimony, and this whole new statute is engrafted on and referenced in Section 34. It's separate from temporary.
Well,
so
I don't know if I would agree.
I
don't know if I would necessarily agree with that, because I think throughout Chapter 208 there is cross references, and I don't think the statutes themselves are always mutually exclusive. And I can suggest that if you compare Section 28A, which is the child support on a temporary basis, with Section 31, which talks about shared parenting plans, the term order is used in the temporary context, okay? And it's used judgment is used in other contexts when judgments are referenced. And so when you consider, I suggest, the intent of the statute, which was to put some predictability into the duration, and in this case, the 80% length of the marriage, based on the length of the marriage at 15 years or so, I think it's consistent with that intent of the legislature to not consider the temporary alimony in the abstract allows for circumstances where the intent is actually frustrated, and I think that is what happened here.
If we agree with you isn't the appropriate thing to do is to remand it to the judge for findings, to see if what are we talking, a 10-year order,
Well, it would be
12
it's
plus 2?
80% of 15 years, so it's 12 years or whatever, 144 months, actually. Yeah.
So if we agree with you, why wouldn't we just say, look, it really appears as though the judge intended to do what she did. It was, the temporary order plus the 12 years after that. But she needed to have explained herself. She needed to justify it. Why wouldn't we just send it back for findings to see if those findings were appropriate?
Well, I think that's certainly the remedy that is a remedy that I would seek. But for purposes of this appeal, Justice Bean, I suggest that the statute includes the temporary order of alimony absent some findings which suggest it was a deviation. And I don't think Judge Blake in this case was considering that as a deviation. I think a fair reading of her judgment indicated that, as Judge Blake interpreted, I'm defining the alimony as not including that temporary order of alimony. So to the extent that it's remanded, I would suggest that the order, the temporary order, be included, because I think that's part of the legislative intent as the word order, its common use is defined.
What if you were to do it what if you're, couldn't you sort of achieve the same thing by saying that Judge Blake was correct in her interpretation of the statute, that alimony, you start calculating from the date of the judgment, but it is free to the alimony payer, in this case your client, to argue that, there was that big period of time where the temporary orders were paying equivalent alimony, and so the general alimony order should not be 80%, but 80% minus, that would be your argument, minus those numbers of months. So he's just pushing it the other way when the burden is then on you to justify going, cutting it shorter.
Certainly, that is clearly that's an option, but I don't think that's consistent with the statute. Again, because I think the use of the word order is such a broad term, and to the extent that the judgment did not say, the statute did not use the word judgment, as Justice Duffley indicated, it has its use in Section 34.
Did the temporary order itself, I don't know this, use the term temporary alimony, or did it use the word alimony in there?
It was a combined order because there was both alimony.
But it used the word alimony.
Yeah, because there was both alimony, spousal support alimony, and child support in the same. These were stipulations of the parties, so it was a hybrid order. It had elements of both, and that's now changed under Judge Blake's order. So I think that certainly, I don't think the common use of the word order is the crux of what I'm suggesting here, and I think that to the extent that the sections 48 through 55 really don't contain any sort of limitation, I think that that's inconsistent with what the plain reading of the statute suggests. And again, I think if you look at throughout Chapter 208, again, in Section 17, Section 19, Section 28, the word order is used in a temporary order context. So it's not and at other times in other sections of that chapter, Section 34, Section 28, the word judgment is used. So I think that in that context, and in light of the fact that in light of the Pierce case, in light of all the uproar, in light of the reform, that the legislature was attempting to put caps on both amounts and duration. And to the extent that there isn't some recognition at the outset of that temporary order, then I think that the statutory intent is frustrated.
Don't you think if the legislature really meant to talk about temporary alimony, it was a simple thing for it to include the term temporary alimony, as opposed to giving it this, well, they said order, and this is really otherwise refers to Section 34, but still I used it inconsistently. And it seems so strange to have to go strained to go the way that you're suggesting, when it would have been a simple matter for the legislature simply to have addressed the issue head on and said, temporary alimony is included within the concept of amount or duration of total alimony.
Judge Lang, I don't know if I can provide insight on that score in terms of what the
Is
legislature
there
was thinking.
legislative history on this at
There is
all?
absolutely none that I could find, and anecdotally, I can tell you that I consulted with members of the task force and so forth, and they told me the same thing, that it's the old adage, you don't want to see legislation and sausage being made, and
Right.
that's essentially what happened here. But nonetheless, I think that if you give the word its common usage, that word is broader than the word judgment.
Well,
And
but here's the thing, you can also read the new alimony statute and all of the intention to set durational and amount limits as really being what happens once the parties are divorced, as opposed to once they're in the process of divorcing, and that process can take shorter or longer periods of time. Different things are contemplated. They may be still living together for some period of time. The monetary arrangements may change. But when they've really sort of when everything gets sorted out, and their property gets divided and everything, custody decisions are made and so forth, that's really when the durational aspect kicks in. That's what the legislature meant.
I disagree. And the reason is when you, again, the definition of the length of the marriage was sharply curtailed under the Reform Act. Prior practice had always been when the judgment enters. That's when the length of the marriage comes to an end. Now it's clearly when the service of the divorce summons is served. And that can be, in this case, far before the judgment enters. And I think in that context, given the shortening, if you will, of the marriage to when the litigation starts, that's when the legislature intended this marriage to be over. And payments of alimony after that fact fall under these durational limits. I think it's a consistent reading of the statute. And as I said, the other aspects that you pointed out, Justice Lang, the other things that are going on during the litigation, and some litigation is shorter and longer than others, those are things that the statute allows the trial judge to consider when issuing a deviation order. The judge can do that. The judge can say, for whatever reason, the discovery wasn't complete, or we did.
Is that in the statute, too, that the judge should consider how long it took to get divorced? I thought,
Well, no,
I thought that the reason for defining length of marriage as of the date of the filing of divorce was because that would be the number of years that you would use to calculate the durational period, just so that you could, I don't know, whatever the reason was that you all did that. You wanted a specific date rather than an uncertain date, because you file it, you know what that is. You don't care how long it takes. It doesn't.
But the durational limits flow from that calculation. And, and again, if you look at Section 53E, it says, and when setting an initial or a modified order, the court can deviate from the durational limits, provided findings are made. And in this case, I don't think Judge Blake was certainly considering deviation. I think she was calculating it as being, not exclusive of the temporary order.
My question was really temporary is temporary. And as you've already heard, the focus of the question is how do you gauge an appropriate amount of support before discovery in a contested action? And when you could have many kinds of orders, just pay all the mortgage expenses. Just pay them. That's not an order for support. Or is it? Well,
It might
there
be.
you go.
It might be. Depending on how the order was defined, and whether or not the.
She gets, if it's a she, a smaller amount for food.
That's true. You're right, but I mean.
The order.
But I understand.
So my question, you mentioned that the temporary order, that the judge, is it in here, is it contemplated, because that would support you. Where is it in the new alimony statute? Is it contemplated that the temporary order amount can be taken into account in the future? You said something very specific. You said, well, the judge under the statute can look to see if someone was really, trying to stretch out the period
Right.
of the divorce and it was acrimonious, and you can use the fact of the length of that and the small amount of the temporary order to increase subsequently. Where
That
is
would be
that?
53E, and that's where it talks about deviation from the durational limits, both in the initial stages and in subsequent modifications. And I think that's the statute that applies, Justice
Oh,
Duffley.
just the general term, okay.
Why shouldn't we look at the period of time between the filing of the complaint and the actual, the hearing on the divorce is sort of like a pilot program, a prototype of what the final product should be. It's a chance for a judge to maybe do some experimenting without having to go through standards for modification or anything like that, and to tweak it here and there and allow the parties to dissolve their union.
But the judge can do that, and the judge can treat it as a pilot program and go beyond and deviate if necessary, if that pilot program didn't prove to be fully equitable. But I think when the Reform Act was crafted to put an end, I think it in this case, the alimony will approach, if not exceed, 100% of the length of the marriage, which is absolutely contrary to what the statute evinces. And so I think the judge is given that discretion, provided the findings are made. And I don't think Judge Blake did that in this case, because I think she clearly excluded, without considering whether that was fair or not, because I don't think she believed it to be part of the calculus. I think it needs to be part of the calculus. I think that's the directive that this court needs to provide to the trial judges and to the bar, at which point then we can argue deviations going forward.
Thank you, counsel.
Good morning, Chief Justice and Associate Justices. May it please the Court. My name is James Walsh, and I represent the appellee in this case, Elaine Holmes. What the appellant is asking this Court to do today is to interpret a statute and issue sort of a hard and fast rule that alimony paid during periods of temporary alimony during the pendency of a divorce will be included and will shorten the durational limits of Section 49 for general term alimony under the Reform Act, Your Honors. What the appellant is asking this Court to do is to read an intent into a statute which has not been expressed by the legislature. As Justice Duffley pointed out, nowhere in the new Reform Act, in any of its sections, is the phrase temporary alimony discussed at all. Temporary alimony is, in fact, a creature of statute. It was enacted in Chapter 208, Section 17, back in 1975. It's been a tool by which practitioners in domestic relations maintain the status quo and help support families during the times that they're getting divorced.
In your experience, am I correct that the period of a temporary alimony is far greater in a contested divorce than in an uncontested divorce?
It very well may be, and certainly, yes, I would agree with that proposition.
So if you're right, would that not provide an incentive to contest a divorce because it would extend the period of alimony?
I don't believe that, because under the new statute, and the starting point should be whether or not the statute even applies in this case, and I say that it doesn't, and I'd like to discuss that in a minute. But to answer your question, Justice Gantz, in any new case that's brought, any new divorce that's filed, the statute is going to apply. And so the length of the marriage is defined right away when the complaint is served on the defendant in the case.
Right.
It's the time frame that exists from the date of the marriage until the
That's
service of
fixed,
the
but the
complaint.
duration of alimony is going
Now-
to be far longer if you drag out the divorce proceeding, would it not be?
It could be, but, Your Honor, in that situation, the trial judge is in the best position to ascertain whether or not there's bad faith on the part of one of the litigants in trying to drag it out for that purpose, to try to increase the amount of alimony or the length of time that it would be paid. I don't think that a hard and fast rule...
That's pretty hard to do for a judge, isn't it? I mean, you may be able to ascertain that the claim of delay is bogus, but it seems that there are many, many reasons for a legitimate delay, and it would be, well, I mean, isn't it? I mean, it would provide an incentive to prolong a divorce proceeding, if
There
you're
are many
right.
reasons for a legitimate delay. There are no
Okay,
reasons
but
for
I
a
mean,
bogus delay.
but I think you have to agree that this would provide an incentive for the person receiving alimony to prolong the divorce proceeding in order to prolong the period of alimony.
I think that situation, could arise, but I think that it can best be addressed and remedied not by a hard and fast rule, because there are problems with a hard and fast rule. The harshness of it would outweigh the scenario that you're talking about. If I could just address that for a moment. So, for example, Justice Boxford addressed this issue briefly. In a temporary alimony situation, that support is given to maintain usually the status quo of the divorcing family. Pay the mortgage, pay the bills, put food on the table, things of that nature. What is not considered in the calculation of that temporary amount is the ultimate division of assets that occur later on in the divorce when it's finalized under Chapter 208, Section 34. Typically, it can be a different amount than is ultimately awarded in a case, and it is in this case. In this case, the temporary alimony was $368 a week, and later on, when the divorce was finalized and a judgment entered in October of 2008, it was $700 a week. So it's a much different amount, and what I would suggest to the court is if the scenario that you are concerned with, Justice Gantz, exists, one party intentionally prolonging the process in an effort to increase the amount of alimony that they would get. The opposite side of that is a harsher result. The opposite side of that is that a person will then, amounts of lesser included alimony will be held against a party later on. For example, in this case, my client got $368 for 2.3 years until the judgment issued. Then it was increased to $700 per week. The difference there is $332 per week. If the court issues the hard and fast rule that the appellant is asking for, includes temporary alimony in that durational limit, she will lose $332 per week for 2.3 years, or 135 weeks. That's a significant amount of money. In addition,
Do you agree that the judge could take into account let's assume that the temporary alimony, or that's the right term, temporary alimony?
Yes, Your Honor.
The temporary alimony turns out to be essentially equivalent to the alimony that's ultimately given. The judge could take that general alimony award and cut off some months. In other words, if the marriage was, if the outer limit was 80% of a 16-year marriage, so let's say they say that's 13 years.
Yes, right.
Make it 11 years or 12 years or whatever, as long as depending on, it would be a case-by-case determination, but there would be no reason you couldn't do that, right?
I do agree that if the new statute applies, that the 80% of the length of the marriage is the highest limit under the statute. So the court would be free to make a lesser amount or a lesser durational period of time, provided the judge takes into account all of the statutory factors that are required under Section 34. I'd like to speak to that, if I may, Your Honor, because this case begs the question of whether or not the Reform Act even applies.
Well, is that before us?
Yeah, you didn't
The husband
appeal.
has appealed.
The husband has
There's no
appealed.
Cross appeal.
We have not appealed that, but, Your Honor, the reason for that is that in the underlying case, the trial judge in the modification action was governed by Chapter 208, Section 37, which empowers the courts in modification actions to revise or alter alimony judgments and make any judgment respective thereto, which could have been made in the original action. The judge in this particular case, Judge Blake, was asked by the defendant's counsel, the husband's counsel, to apply the new Alimony Act, to apply the durational limits, but in the wrong amount. He calculated it at 70% rather than 80%, and counsel asked the court to include the period of temporary alimony in the overall durational limit. On behalf of the wife, I did not ask the court to apply the new statute. She said that in her rationale and
Yeah, she
findings
did.
that I did. But if you look at the proposed judgment that I filed in that court and the proposal for judgment, I asked her not to, but I said that if you do, please apply it correctly. And I went through an analysis of the breakdown that way. But my position really is, in that case, that the judge had the ability in the modification action under Chapter 208, Section 37, to do whatever she wanted with the alimony amount, provided she had the facts and considered all of the statutory factors under Section 34. It's quite apparent from reading her judgment that she did consider all of the statutory factors, and she did make findings. She did find that the husband had an ongoing ability to pay. She did find that the wife had a need for alimony, and she reallocated the support of $1,300 a week all as alimony. And then in setting the termination date, where she did, it's true that she did apply the 12 years under the new statute, the durational limit, which would apply, but she could have done that under Chapter 208, Section 37. She could have ended it in 12 years under 37, or she could have ended it in 13 years, or she could have chosen not to end it at all, or perhaps she could have chosen some shorter period of time. So that's why the wife didn't appeal that matter, because we felt that the judge had the discretion under that statute to do it. How she got to that point, we think, was wrong, because we think that she applied the statute when, in fact, she shouldn't have under Section 4 of the Act. It says it only applies prospectively, the durational limits, that is, Your Honors, to actions, to alimony awards after March 1st of 2012, where this one predated it by 4 years. But assuming that the court finds that the Reform Act does apply to this particular case, we still don't get to the position where this concept of temporary alimony should be included in the durational limit under 49, Section 49, because the statute simply doesn't say it does. If you look at Section B of the appellee's brief, I discuss those concepts in law about whether or not this court should substitute its judgment and insert words into a statute. Yes, Your Honor.
Well,
I'm
I mean,
sorry, I
that
was
cuts
going to
both
let you
ways. I
finish
mean,
your sentence, but I do want to ask you then, if we're looking at the statute as a whole and looking at all the provisions in the statute, under Section 52, the legislature knew how to say, and as they said here, let's see, transitional alimony, not longer than 3 years from the date of divorce, right?
Yes, Your Honor.
Is that term used anywhere else?
From the date of divorce? This is interesting because I haven't seen it, but Your Honor focused in earlier about the different uses of the term order and judgment throughout different sections here.
Pretty clear, right?
That's very clear,
And
Your
they
Honor.
could have, they knew how to use it,
They knew how to
and
use
they
it.
didn't use it anywhere else.
That's correct.
So what do you say to that?
I say that if this court is to interpret this statute as including temporary alimony in the calculation of the durational limits for general term alimony under Section 49, that language needs to be in the statute, because the legislature had to be aware of the existence of the temporary alimony statute since 1975. Your own holdings of this court presume that when the legislature amends or enacts a new law, it is presumed to know about existing laws in that area. This legislature, in enacting this new Reform Act, chose not to say anything at all about temporary alimony, did not include that phrase anywhere in the text of the new statute. We must presume that they knew about it. This particular court's holdings consistently over the years are that you will not substitute your judgment for that of the legislature. You will not put words into a statute which the legislature did not see fit to put there. And if this court were to find that temporary alimony should be included in the calculation of durational limits, you'd have to do that. You'd have to go back on the consistent holdings that this court has issued over the years.
Well, is it your view that temporary alimony is not alimony as defined in Section 48?
It's my view that temporary alimony is not to be included in the durational limits of Section 49.
Okay, that's not my question. My question is, Section 48 defines the term alimony. Is temporary alimony within that definition?
Temporary alimony is a hybrid. It's a different animal than alimony. That's my
So
answer.
you're saying that temporary alimony is not within the definition of alimony,
That's my answer, yes, Your
even
Honor.
though temporary alimony is nowhere defined?
That's correct, Your Honor. My thought on this is that if the legislature intended to include temporary alimony, they would have discussed it and they would have defined it as such, and they would have included it in its discussion of the durational limits in Section 49. They chose not to do that for a reason. It would be sheer speculation for us to try to guess why they did that or why they omitted it, just as it would be sheer speculation to try to understand why Judge Blake didn't include the amount of the temporary alimony in her calculation of the duration limit when she was specifically asked to do so. She didn't mention anything about it in her findings. And this brings me to
Well,
Justice...
should we send it back to her?
I was just about to address that. Justice Spina asked that when the appellant was arguing. That may be the appropriate thing to do in this case. There's not reversible error here that requires a reversing of her order, but perhaps a remand for additional findings might be necessary with some guidance from this court on the specific question of whether or not temporary alimony should be included within the calculation of the durational limits. I suggest respectfully, yes, Your Honor.
I was going to say, if under the statute, if a couple's been married for 1 year, the alimony statute only provides for the payment of alimony for 6 months, half the length of the marriage. I mean, even an order of temporary alimony under an action, while the action is pending, in all likelihood it's going to terminate before the
That's correct. If this court were to issue the blanket ruling that the appellant is asking, that would be the effect in that scenario. That would be the effect. It's my sincere belief that probably the best course where it's not been expressed in the statute, whether or not to include temporary alimony, is to leave that to the discretion of the trial judge in the calculation of the durational limits. The trial judge, these cases are so very fact-driven and fact-specific. One family's needs are different from another family's needs, and to have a cookie-cutter approach to the duration of alimony would not, in my view, be the best approach. I think the best approach would be to leave that to the court's discretion, let the trial judge decide whether or not to include periods of time. The parties can argue at trial whether or not they should be included and give supporting reasons for their positions, and the trial judge is in that best position. And with that, Your Honors, unless there are any additional questions, I will rely on the remainder of the brief I submitted.
Thank you, counsel.
Thank you, Your Honor.